United we're as strong as a mountain.
I'm Gabriel Prawl, president of the Seattle chapter of the A. Philip Randolph Institute, past president of ILW Local 52, and executive coastwide executive co-chair of the African American Longshore Coalition, and Puget Sound co-convener of the Million Worker March movement.
Nice to meet you, Gabriel.
And my name is Leith Call, and I'm the chair of the Education Committee of ILWU Local 19, Longshore Division Local 19, Seattle, Washington. I'm also a member of the A. Philip Randolph Institute, a member of the African American Longshore Workers Coalition, and a member of the Million Worker March movement.
Hi, everyone. Good morning from Oakland, California. My name is Kavena Hambira. I'm a Namibian filmmaker, currently pursuing a master's here in UC Berkeley in the Bay Area. I've worked with Steve since 2012. In fact, my first work was centered around the International Longshore Workers Union here in Oakland, Local 10. My first project was actually screened at Labor Fest in 2015 at Stanford University. So currently working on a project with Steve to raise awareness around some of the challenges in West Oakland and the docks. And I'm hoping we could hear how we could support our brothers and sisters in Namibia. Thank you.
I'll introduce myself. My name is George Martin. I am the secretary of the Rossing branch or the unlawfully dismissed, the 9 unlawfully dismissed Rossing China National Nuclear Corporation. I've worked for Rossing for the past 14 and a half years. Thank you for having me, and apology for being late with a few minutes.
Good evening, fellow comrades. My name is Julius Ashipala. I'm one of the 9 unlawfully dismissed branch executive committee members. I held the portfolio of the Secretary for Information and Mobilization. I worked for Rossing for almost close to 10 years. Thank you.
Paul Thompson, member of Labor's Local 242, and also the vice president of A. Philip Randolph Institute, Seattle chapter. Glad to be here.
I'm Jonas Antenya. The English version is John. I'm chairman of the Rossing, MUN Rossing branch. And I'm glad to be here.
Well, I want to bring greetings to each and every one here. I want to thank you for joining us and participating. Also, our guests, I want to thank you for willing to share your struggle with us here as workers united. The struggle that we see happening and that you brothers are fighting is the same struggle that workers here in America are fighting as well. The attack on workers is not just locally, it's internationally. And it's in great encouragement that we fight together the struggle that we are fighting, because that's all we win by uniting our forces. And at this point, I want to give this panel, I want to pass this on to Brother Lee to say a few words of encouragement and also to begin this conversation and panel.
Thank you, Brother Gabe. Leith Call here, member of A. Philip Randolph Institute and the Education Committee of ILW Local 19. I think that the 4 of us on this call from the United States today are hoping that this is the first of a a series of expanding conversations between the labor movements of the West Coast of the United States and Namibia. I know in particular there's several aspects of the struggle that I'm very curious about as a member of the ILWU, although I'm not a miner, I'm a longshoreman. But there is a section of miners. There is a local of mine workers that's represented by my union in Boron, California. It's local 30 of the ILWU, the Mine, Mill, and Smelter Division. And these workers work for a corporation called Rio Tinto, which I understand used to own the mine that you brothers in Namibia work at up until 2018 or 19. And there's a series of struggles that you can see on the internet if you simply Google ILWU Rio Tinto. The Rio Tinto Corporation there ended our defined benefit pension plan. They took away our pension through a means of a lockout in 2009 through 10. And there was an effort to fight back and defend the pension. Ultimately, the effort to defend the pension failed, and it was transformed into a much reduced 401k program. So we're familiar with how anti-union, how anti-worker Rio Tinto is. And it's hard for some of us to imagine an employer being worse than Rio Tinto. But from what we're hearing from Namibia, it seems like possibly the China Nuclear Corporation is going for that. They're possibly going for the distinction of being even worse than Rio Tinto. So I'm very curious in finding out more about that and about the history of your mine, how long the mine has been in operation, and when Rio Tinto came into the picture, and how Rio Tinto came to sell it to the Chinese corporation, and how that how your struggle as workers there has played out over that series of events. And also, of course, as a transport worker, I'm always very curious about the industrial relationship of every mine in the world to the markets that its ore is mined for. For instance, a question I have is any of the material mined from your mine coming to the United States, or is all of it at this point going to China? So to satiate my curiosity and the curiosity of the other Americans on this call, I'm going to turn it over now to George Martin, NUM Rossing Branch Secretary, and John Hamutenya, NUM Rossing Branch Chair.
Thank you for the opportunity. The chairman will give a summary or a brief history of our struggle, and then I can come in and help you. Comrade Hamutenya.
Thank you, comrade. I think first of all, we are very happy that we are offered such a platform. Briefly, we are going to touch on the issue that we faced during our stay as branch executive members of China Nuclear Corporation. But just before I do that, I would like to answer your question as to whether some of our products, the material that we mine, is being sold to the United States. And the answer is yes. We've been mining since 1976. Officially 1978, we've been mining uranium, and it's always being exported to United States, France, and the UK, and Iran, and a few other countries as oxide, uranium oxide. So United States is one of the biggest buyers under Rio Tinto contract. Under the Rio Tinto contract, United States was one of the biggest buyers. However, under the Chinese, they are still one of the buyers because the Rio Tinto contracts are still intact until 2022, I think. Until 2022, only then they will basically then expire. Those contract that the sales contract that Rio Tinto signed with the United States. But as from 2022 or from 2026, what we were told is that from there on, the Chinese government or the Chinese National Nuclear Corporation, they will be producing for their own consumption. So that's on your question as to whether in your question. Good. With that said, I quickly would like to run you through our struggle. Our struggle, yes, under Rio Tinto we had such struggles, but because most of our conditions were born just before independence and directly after independence, so we had better conditions of employment. Better condition of employment, some of the best condition of employment in the entire country. So now with the taking over of China National Nuclear Corporation or China National Uranium Corporation, the first thing they did is to want to reduce those conditions, basically change them from what they were to something else, to something lesser, something worse than our current conditions. So they did that by writing, for the first time in history of salary negotiations, they wrote us the first letter, the letter demanding to reduce our conditions of employment. One of the conditions of employment they demanded reduction on is the leave day. So they wrote us a shopping list of conditions of employment that they were intending to minimize or reduce. So one of them is the procedural agreement, of which they wrote us a letter saying that they want to renegotiate. Now the procedural agreement or the recognition agreement is the document or is the contract between Mine Workers Union and Rossing as an entity that allows us now to have that social relationship or that social partnership for us to be able to represent Rossing employees as the official union or sole bargaining agent for all the employees. So that's a very important document. It's important twofold. It has some of the best conditions or terms in the entire country, and two, it was the first document, procedural agreement signed in Namibia as far as mines are concerned. It was signed in 14 November 1988, just before independence. So our leaders then, which some of them ended up being politicians, ministers, all those stuff, they made sure this document was so good, sound enough to represent what workers stood for. It covered all aspects of the relationship. So it has always been a thorn in the flesh. It has always been a thorn in the flesh. So with the Chinese, when they came on board and they saw this document that gives employees so much rights, so the first thing they did is write us a letter claiming that they are entitled to renegotiate that document. We received that letter and we wrote them a 2-page letter in response, of which we requested a number of things. And one of the things that we told them that in terms of our Labor Act, our Labor Act prohibits employer from reducing the prevailing conditions of employment. So if you are intending to renegotiate this document, then the only way we can accept is that if your proposals are to better the current conditions that we have in this document, whatever other document that you want to renegotiate. So we wrote them a letter in that context, and they never replied to that letter. They never replied to that letter to this day. Meanwhile, they submitted now during salary negotiations, because that document allows us to basically negotiate on conditions of employment and salaries every year. But then it also explicit makes mention to say that you can only renegotiate a right or a condition of employment unless the other parties agree. So of which then all the conditions of employment that we already signed were basically protected. And also the Labor Act emphasizes or says the same thing, that the only conditions that can be renegotiated or the only right that can be renegotiated is the right that two parties agree to renegotiate. If the other party has a right, that right cannot be renegotiated unless the other party consents. So with that, we're comfortable to say, okay, yes, they are not going to renegotiate some of these rights because because in terms of the procedural agreement, in terms of the Labor Act, we need to consent to the renegotiations. So during the salary negotiation, they then demanded to say they want to renegotiate the leave days. We had negotiated for better leave days. The basic conditions in terms of the law, the Labor Act 11 of 2007 says an employee that works shift is entitled to 24 leave days, annual leave days a year. While an employee that does not work shift, who works Monday to Friday, is entitled to 20 leave days a year. However, the union at Rossing branch, we negotiated for much better conditions of employment. So we were entitled to 40 calendar days, 40 leave days a year. So with that, they wanted that to be reduced to the basic conditions of employment. They also wanted to reduce, which is 20 and 24 respectively. They also wanted to reduce our sick leave days. Our sick leave days, basically, we are entitled to, in terms of the agreement that we signed with Rossi, we were entitled to 126 sick leaves in 3-year cycle. So they wanted that to reduce to 36 in 3-year cycle. They also wanted to reduce our effective date. In terms of our agreement, the salary effective date is every year, January. So they wanted that reduced. And then there was another thing, Comrade George, what was it that they wanted to reduce during the salary
discretion? Salary
Good.
discretion.
Good, thank you. Now, in terms of our, because of the past discrepancies or disparities or the apartheid era and all those stuff, the disadvantages that happened, the government enacted a law called Employment Equity Act or Affirmative Action Act. This law says that all people should be paid, people doing the same job must be compensated equally. So if you're all technicians, you should pay the same salary. If you're all operators, you should pay the same salary. People in the same grade doing the same function must be paid the same. That's so that they can close the gap between what was done before independence and now. And also, that same document also then says there shouldn't be discrimination between a woman and a man. So whether you are black, white, green, female, male, you should all be paid the same. Now, so on top of that, we signed another document called Classification of Structures. Classification of a structure is basically just to localize the equitability in terms of salaries that was contained in the AA. Now, to localize it so that we put it in structure and see how it will be carried out. So we signed that document. So since 2012, when that document was signed, employees in all grades were paying the same salaries, the same benefits across the board. As long as you are in the same grade, you're doing the same functions. When the Chinese management came on board, they were very strategic. One of the things they did is the general manager, the general manager human resource that position was given the Chinese general manager. So which means he had the overseeing responsibility of all the pay scales and all these things. I think that's how they identified some of these things. So they demanded that they wanted to retain the right to salary discretion, meaning they wanted to decide on how much they pay employees. So you can be doing the same job, but you'll be paying different salaries, although the same job, same function, the same title you'll be paying. So they demanded the salary discretion, of which it was already our right, which was not new because we have a sister mine that started in 2014, am I right? Swakopmund, a Chinese, 90% Chinese owned, Chinese management, everything. That's what they do. You have two artisans, for example, that do exactly the same job, but their pays or their remuneration They can be 10,000 or 20,000 different between the two employees. So they wanted the same thing to be implemented. And also what we have seen with such a system is that depending where you are coming from, if you are coming from a job where you were paid $2,000, when you join them, maybe they'll just add $1,000. No, $2,000. I'm referring to Namibian dollars, not United States dollar. While if you're coming from another organization where you were paid, for example, 10,000, they'll just add 1,000. So, but although the person that's coming from company A and the one that's coming from company B, they are coming to do the same job. You interviewed them exactly the same day. You gave them exactly the same contract, the same job description. But because of where they are coming from and what they were earning there, their pay salaries also then differ. So they wanted the same thing to be applied, of which we said, no, you cannot do this at Rossing because we already have agreement in place. And in terms of the Affirmative Action Act, this is illegal. It's discrimination. So all these things, they could not succeed. As a result, they then said, if this is not done, then the salary agreement for 2020 will not be signed. So it stalled the whole salary. It stalled the whole salary negotiations. Stalled the whole salary negotiations. And in addition to that, the employee tactics were, in terms of our procedural agreement, you cannot communicate to the other parties' mandate givers. So after negotiations, every party must go to their various mandate givers and give feedback. What they did under the Chinese management is that they started now, to the exclusion of the union, meeting our mandate givers secretly and then influencing them to go against us. That no, we gave this to the union rejected, and all those stuff. And also, they started writing us threat letters because for one of the things that we said, they refused us to do the voting. In the Namibian context, in terms of the Labor Act, if the two parties cannot reach an agreement, if the two parties have deadlocked, you go to the labor, you go to the labor commissioner. Then the labor commissioner then listens to your case, try to reconcile the two parties so the parties can reach consensus. If the party fails to reach consensus, then you are issued with a certificate of unresolved dispute. With that certificate of unresolved dispute, either party can then, as the employees, we can then strike, of course, follow the procedure, notify them that we're going to strike, come up with the rules, and then we notify them within 48 hours that we're going to strike. The other part, which is the employer, they also then have the right, after receipt of such a certificate of unresolved dispute, to then notify us, come up with the rules and notify that they're going to lock us out. So when we wanted to do voting, when we wanted to vote so that we can determine whether the employees want to strike, our procedural agreement gives us access to this to do the voting, or to do the voting on site, and we've been doing it all along, no problem. When we wanted to do that, they refused that access to the facilities where we should vote. And then we notify them that, okay, if you are refusing us, then what we'll do, we'll utilize our umbrella union, mother union facilities, and we'll call the labor commissioner inspectors to come and supervise the election, and we'll notify you on the outcome of the election. When they heard this, they threatened us in our personal capacities. They wrote letters to the labor commissioner. They wrote letters to our national executive committee, accusing us of so many things. So and then letters kept on coming. Letters of threat kept on coming. One of the letters of threat, they threatened the chairperson in personal capacity. That there were two letters of that nature. They threatened to terminate this agreement that they wanted to terminate. That this this document, some of these documents they wanted to renegotiate, especially the procedural agreement. They wanted it, they threatened to terminate it. So they wrote a letter to the National Executive Committee, the General Secretary of Mineworkers Union, MUN, Eben Zarondo. They wrote him a letter to say the union is misbehaving. As a result, if you do not discipline them, if you do not take actions against them, we are going to terminate the procedural agreement, of which it's cowardice, because if the other party has violated or has breached any terms in that procedural agreement, there is a process. You go to the labor court, you go to the labor commissioner to prove that the other party has violated the agreement, and you make up some demand to terminate only that part that has been violated. But instead of doing that, what they did is, because they were in bed with our National Executive Committee, because they were in bed, they wrote them a letter to say we are going to terminate, putting up a number of threats against us and against our agreements. Then the National Executive Committee, instead of consulting us, the General Secretary to be specific, instead of consulting us, what he did, he wrote us a letter of threat also, threatening to discipline us, and of which is unusual, because allegations have been leveled against you, and then instead of against your people, instead of you investigating or finding out or even calling or consulting your people as to whether these allegations are true that has been raised by another organization, you just write them a letter of threat. On receipt of the letter of threat, what we did, we told him, no, you have no right to communicate, to deal with us directly. In terms of our agreement, this is a process that issue must be dealt with. And if you had the workers' interests at heart, one of the things that you would have done is investigate whether those allegations are true or not. And in addition to that, we reminded him of a meeting that we had with him earlier in the year, I think that was March, in which we briefed him of the activities of the Chinese, and of which he promised to get the government intervention, to get the political interventions, to get the legal intervention. We reminded him of those things. And on receipt of the letter, he kept quiet. But the Chinese never kept quiet. They followed up with another letter, and that letter was now to terminate our access to the archive. So as a union, we have an archive, a physical archive where we keep all our records. And then we also have an archive on the system where we keep also our electronic documents and records. And then we had full-time employees. Myself as the chairman, I was full-time. And then we had the full-time shop steward who was full-time. And then the chairperson of the safety rep, also a union portfolio, he was also full-time. So on the 2nd of June, they wrote us a letter to say that as from the 2nd or the 1st of July, we no longer have access to these facilities, to these offices, and to these archives and all those stuff. And also, they wrote another letter in the same week, wrote it to the same general secretary, reminding him, when we demanded that we are going to vote, they reminded him of a letter that they previously wrote, and then they did, this time around, they directed him, you must punish this you must punish this branch executive committee. They actually demanded on receipt of, when the general secretary of MUN received this letter from the Chinese management to say, in which they demanded him to punish us, to discipline us, he came down plus minus 400 k's away. He drove with MUN president to come and meet us, and the intention was basically then to discipline us. So when they came and met us, the first thing that we did is to ask them, in terms of our constitution, where is this meeting provided for? Where is it sitting? Because in terms of our constitution, the president and the general secretary, they cannot directly be dealing with us. There must be a chain of command. We have reporting structure that we follow. So when they had this letter in their hands and all those stuff, when they saw that we are well acquainted with our procedures and our constitution, so they backed off. They basically just backed off. But then we said, no, we want to engage you on the content of that letter. We want to give you evidence of everything and all those allegations that's contained in that letter, so that you can go back to your masters, and ask them for proof of all these things that they are alleging. And so we took them through. We basically gave them all the proof to show that these guys are basically busy with union busting. They want to eliminate the union inside. We showed them letters in which they requested to renegotiate those procedural agreements. We showed them letter in which they requested to renegotiate the leave days. We showed them letter in which they requested to renegotiate our recruitment policies, in which they requested to renegotiate the performance and conduct procedure or the disciplinary policy. And on seeing all this information that we gave them, they then promised to say they are going to them and they will call them to the meeting so that we can discuss this thing. Because now the eyes are open to say the Chinese are actually the ones that are wrong. They never came back. They went, and that was the last time we saw them. So, because during that time, during that sitting, during that consultation, we were given an ultimatum that by the 1st of July, we should vacate the offices. We also showed the national executive this letter and the regional executive this letter. Then they advised us to say, no, this letter is very serious. The only way we can deal with this letter is that you comrades should go and consult a lawyer so that the lawyer can then take up this matter. We got the lawyer, and then we got the lawyer. That lawyer basically then we gave the invoice to them and all those stuff. Now, when we gave them these invoices, they said, no, this lawyer is a pro-employer. You cannot be utilizing this lawyer. The reason because the pro-employer. The information I'm going to mention next, I want us to keep it between us because we have a case that's ongoing, and I don't want it to go out there. They will use it as evidence, especially what I'm going to mention next. So that's how we then went to consult the lawyer that they advised us to, and of which they said that lawyer, they already have an account and all those stuff. And when we consulted that lawyer then raised these issues with them, say that, why are you terminating, why are you removing these rights that the employees have been having all along? Why are you now removing these rights from them? And when the Chinese management received such a letter from the lawyer, the first thing they did was to write a letter to our general secretary, to the general secretary of MUN, Ibn Zarondo. Now, when they received a letter, when Ibn Zarondo sent them that letter, they inquired as to whether or not they were Ibn Zarondo and his co-host were a party or were involved, or they gave authorization to us consulting a lawyer. Ibn Zarondo, MUN General Secretary, he responded. Basically, in his response, he said they were not involved. The Rossing branch, which is us, we are the one that did whatever we did. And then another regional secretary followed up with another letter in which he said, of course, they had, although they exchanged this letter, behind the scene, they had a lot of discussions. Because if you see them they wrote a letter inquiring whether they were involved, of which then they denied the involvement. And then the regional secretary, the regional chairperson of MUN comes and sends a letter sent out a letter which was also spread on media saying that as a branch, we do not have the right to consult a lawyer. On those basis, the Chinese management then decided to suspend us. So we were suspended.
What also led to the meeting with the lawyer was on the 21st to the 23rd of June 2020. We had a meeting with the Affirmative Action Committee and the HR Human Resource team of Rossing. We were busy resubmitting the affirmative action plan of 2019 that was rejected because we wrote a letter to the Equity Commission on the plan that was submitted, because when a company draws up a plan, the union must be involved in everything on that plan. The management did not involve the union, and they went behind doors and sent that plan, the 2019 plan, and then it was rejected and sent back to Rossing. In those days that I mentioned, we had a meeting to resubmit the plan. So when we saw the plan that was going to be resubmitted, we came across a lot of inconsistency in the plan that we corrected. But the main one was we saw that every foreigner on the plan had a page with all his qualifications, the specialized skills that they possess, the understudies that they have, and the duration. Because we have an agreement that says a foreigner can only work for 2 years, and then if the skills are not transferred, the motivation letter must be written, and then the foreigner can stay, or after his 2 years and the understudy is ready to take up the role, then the foreigner must leave the country. Now, on the plan, we saw that the four Chinese nationals did not feature, or they did not have their own page. We questioned that to the HR team, to the human resource team, and the only response that we could get from the human resource manager acting at that time, she said that they will feature as footnotes on the plan, of which we questioned to say, but these are foreigners, and we want to know who's understudying them. How did they get to Rossing? What skills they possess? What qualifications do they have? Of which the human resource manager could not give straight answers. But the only thing that she said is that they are going to put them as footnotes, of which we rejected and said, yeah, we cannot allow this because they are foreigners and they need to go through the right process and procedure that we have, because as a union, we are a co-signatory to all the agreements on the mine. Now, one of those is the understudy and secondment agreement, of which this agreement governs it governs the foreigners on site. And most of the requirements that are there is a foreigner must only work for 2 years. It must be any foreigner must be understudied, and when two foreigners come to Rossing, 2 Namibians that work for Rossing are also exchanged. That never happened, and the company just went on. So that prompted us to see the lawyer with the threat letter that we got. Comrade Amtenya, you can continue.
So in the letter, so what happened then when they received that letter from the lawyer then basically, their lawyer then wrote a counter letter. So when their lawyer wrote a counter letter, that's when our lawyer then provided proof that these people are basically illegal. They're not supposed to be at Rossing. They are not even supposed to be in Namibia. And in terms of the Immigration Act, they are criminally liable for they are criminally liable for criminal violation, for violating that Immigration Act, which is a crime, and she should be arrested. So he explained and gave proof of all this, and led a few explanation to that effect. So then they never replied to that later again, because now they realize, these people are actually right. These people are actually illegal, and they are unlawful in Namibia. They're basically criminals. We then got suspended. And during our suspension, they then conducted an investigation, and they just made up a lot of allegations to basically then get rid of us. And during that same time, the migration control, they heard about these things, because some of them, it ended up in the media. So when they heard about this thing, they went to investigate these facts. And that's when they discovered that, yes, indeed, these people are illegal in Namibia, and they are in violation of the Immigration Act, and they were arrested. 4 Chinese were arrested. Cases 9 on the 5th of August 2020, closer to midnight, they went to take them out of prison. So the next morning, that's when we had. So we had community members, people calling us and telling us that, no, the people has been released out of prison and all those stuff. So how? These people they're supposed to be appearing today at court. Why they were released? So we went to the station commander, and then the station commander was also shocked to learn that they were released, basically, and who released them, they don't know. So the station commander told us that, no, in my books, these people should be appearing today in court for those allegations or those criminal activities against them. Unfortunately, to this day, the investigation has taken place. All we have is that, yes, indeed, the people were released unlawful from custody, and we have given statements to the police. We have given all the proof that they were illegal, and the police are also afraid to arrest these individuals. And we don't know whether the people are actually in Namibia or they've jumped the border and flee back to China. And if they did flee back to China, in terms of the Namibian law, you cannot prosecute in absentia. So in a nutshell, this is what transpired. The main thing is that they wanted to change our agreements, and our refusal to agree with them led to basically to our dismissals. The whole hearing process was totally unprocedural and illegal. They denied us representation. They did not want us to have representatives of our. Just excuse me.
As the chairman said, we went through an illegal process. We decided to follow the internal processes with regards to the disciplinary hearings. We complied with everything that they did. The main thing when we wanted to represent each other, the management or the chairpersons of the hearings refused to let us represent each other, whereas our disciplinary codes give us the right to represent each other, and our constitution is also clear on the representation. So when we wanted to represent each other, they refused and walked out of the hearings and have had hearings at other places in our absentia. So we were subjected to this unlawful, unfair labor practices during the disciplinary hearing. Comrade Chair.
So we were dismissed under those barbaric procedures, and the union, the National Executive Committee, of which one of the evidence that was used against us in the hearing was the fact that that letter that came from the National Executive Committee saying that, in a paraphrase, saying that we acted on our own, we did not act as unions. So we're accused of serious allegations. One of the allegations that they accused us of is apparently bring the company's, dishonesty or negligence, and then bring the company's name in disrepute, and dishonesty. No, they accused us of negligence, or alternative gross negligence, or alternatively dishonesty, bring the company's name in disrepute. What is it?
And breach of individual contracts. Breach of individual contracts.
Breach of confidential contract, of which all these things are basically false and unfounded, because as union officials, we have the right to media, we have the right to freedom of expression, we have the right to give media statement left and right, and this is what we've been doing all along during the Rio Tinto regime, and even during the Chinese regime. We've been giving media. The only thing is that they felt that we are too much of a headache to them. We are too much ahead of them. We do not compromise on our standards, and they didn't know how to deal with us. So the only way they could find, the easiest way to deal with us, is by basically dismissing us. And for them to dismiss us, they need to work with the head office, and that letter in which the general secretary said that we act. They were not. It's not the union that did it. And in addition to that, the letter from the regional chairperson that says that we do not have a right to go to the lawyers. Those two letters gave them a right to say that we were not union officials when we acted. We acted as individuals, of which is very, very false. I don't know. Yes.
Another thing is, when it comes to the Constitution, it's very clear that the branch runs its affairs as it sees fit. So when we appoint lawyers, we notify them that we notify the region and the head office, because the payment of that lawyer comes from the head office and the region. So that's why we notify. But when we appoint the lawyer to represent the branch, that is the branch affair. So we did not act out of step, out of boundary, because we were within the confines of we worked within the confines of our constitution.
Even the Labor Act, within in terms of our procedural agreement and all those stuff, we were just purely sold by our own people. We're purely sold by our own people. But the fight that we've been fighting for now, it's become very difficult. All the employees are afraid to spend. The Chinese now, they're doing as they please. So basically this is a little bit of our story.
At this point, I would like to open it up for people that want to ask some questions, and that way you can use some of that more rest of that information to answer questions with time. So I want to open up for Q&A. So anybody have a question, you can just raise your hand or put something in the chat or something. So the floor is open.
Let me just start by thanking everyone that had an opportunity to speak. I'm thinking through a lot of the information you shared. But primarily, I want to know if you consider the timeline how your case has unfolded, what degree and how far along are you with regards to the conciliation, mediation, perhaps even the arbitration process? Where are we within that process? Because I did hear you allude to working through the Office of the Labor Commissioner. I don't know if Bro Matthew Shingwaja is still the Labor Commissioner. And what feedback has come from that office? Because one would understand that procedurally, things would have to work through that office. And I just want to understand where we are.
We have two pending cases with the Office of the Labor Commissioner. The first case is unfair labor practices. We filed that case while we're still in employment. It had a first meeting of which we turned out to ask for the recusal of the arbitrator because she was siding with the company and only listening to one side. The arbitrator currently wrote us a letter back or informed us that she's not going to recuse herself. So it is scheduled for the 27th of April. And we also consolidated the matter. Previously, we filed single cases. So we consolidated the matter. So we applied for consolidation. That is the first case. The second case is unfair dismissals. We had two meetings. The first meeting, the company representative did not turn up. The person that represented the company was the person that was the chief investigator, and he had an interest in the case also. So he came to listen or to sit in that case, of which we told the arbitrator that this is the very person that investigated, that was the lead investigator into our case. The case was postponed to Feb. It was heard in February, of which the second time also the company's lawyer, the representative of the company, got sick the Sunday before the case. The case was scheduled for the Monday, and then the Sunday before the case could be heard, he got sick. The same chief investigator came to the case with a sick note, and it went over again to say that he's not supposed to be sitting in, because that same investigator is also the witness for the company. We agreed to set aside 3 days for conciliation and arbitration from the 19th of April to the 21st of April. The case would be heard for conciliation and arbitration. So we are still in that phase. And to answer your question, Matthew Shingwaja is still the head, the director, the ED. He's still the ED at the labor offices. While we still with the disciplinary hearings, we tried to seek support from the governor of Erongo region, of which he also reached out to the labor officers or the ED of the labor, which the efforts and all those trials from the governor felt on deaf ears. We did not get any support from the ED. So that's why we are running the cases through the normal process. I hope that answers your question.
I'm Heward Bekers. I am from the Workers' Advice Center. I'm also the leader of the Workers' Revolutionary Party. The Workers' Advice Center is representing the 9 dismissed executives. I just like to make a short explanation. The both the collective agreement and the employment contract of the 9 persons have not been complied with. The disciplinary hearing that took place was not based on the employment contract. Neither could it be based on the collective agreement, because the collective agreement is an agreement between 2 legal persons, which on the one hand is the mine and the other is the union. The mine management has no business to discipline officials of the union. That was the situation. But right from the start, the objective of the mine management was clearly to oust the union from the mine effectively. That is why they didn't allow these persons to represent each other, because the law, the Namibian law, makes provision that union officials may represent workers. That is a given. And the moment they said, no, you are not going to represent, it was your colleague, it was a statement that the union no longer existed at the mine. The next situation was this, that right from the start, there were irregularities. Conciliation, the so-called conciliation that took place, was followed by a pronouncement by the arbitrator that the next hearing would be arbitration. At the next hearing in February, it was not arbitration, he continued with conciliation. And the case was set down now for the 19th, 20th, and 21st of April. The first day will be so-called conciliation. I impressed upon this man that the case is by its very nature urgent. It is urgent because workers in Namibia have union rights. The fact that the union branch executive had been expelled means that the workers who pay monthly dues to the union are not being serviced. And therefore he has to take cognizance of it, because unions are registered with the Labour Commission's office under the Labour Act. And so this case needs to be expedited urgently, as it is a direct suspension of fundamental rights, and in particular union rights of workers, that was won since 1978 through very violent, in fact, since 1971, through very repressive struggles, but until the workers won union rights in 1984. So this was an effective suspension of union rights, and it pertained to the entire Namibia. I explained to him that this is the last bastion, and if this falls, then there will be no union rights in Namibia anymore. That is why I think the comrades have omitted to state that this case is launched within the ambit of the union struggle throughout the whole country. That includes mines, and they have been able to unite with the fishing workers, with the workers in Tsumeb who face eviction from the old compound, contract labor, hostel, etc., various struggles that they are acting as the vanguard of the union struggle at the moment. It's much more than just a simple labor case. The way in which we approach this case is that it is not an unfair dismissal. It is a plain illegal dismissal and a transgression of the most foundational laws in Namibia, striking at the very heart of the struggle of the nation for proper rights. It is definitely not the focal point is not these 9 persons. Yes, their personal rights have to be redeemed, but the central issue which they understand is that this is a do or die fight for union rights in this country. That is why they have started to unite workers all over the country. The legal situation is this. The dismissal has absolutely nothing to do with the provisions of the employment contract, the terms and conditions. Furthermore, they have been dismissed because of alleged actions that they took as the branch executive. That means that they have effectively dismissed them in terms of the collective agreement. Now, the collective agreement where there are disputes are regulated by Article 6 of the collective agreement, but there's absolutely nothing in 6 which allows them to take action against individuals in the union. The fact that they are taking legal and punitive actions against individuals in the union means that they have suspended the rights of the union. It is a sad state that the leadership of the union do not act in defense of the union, because if the Chinese get it right to expel these 9 workers, then it's the end of the mine workers union at that mine and also at the rest of mines. They will be like the state unions in China themselves. This is the ambit of this struggle, and this is the way we treat this struggle. It's around this that we have advised them that to make this a statement, because our judiciary here is a questionable judiciary, and the agreements between SWAPO and the ANC during the 80s were specifically made to suppress. They made an actual express agreement between the SWAPO in London, ANC in London, and during the 80s with SWAPO, that social justice is not part of the package. And these are the consequences of those agreements.
A couple of questions. I noticed in newspapers like the Namibian, there are occasionally calls by some members of your parliament for the nationalization of mines in Namibia. So I guess three questions really. What is the relationship between the movement for Namibian independence and the idea of nationalizing mines? And then two, what is the relationship between the trade union movement in Namibia and the concept of nationalizing Namibian mines and minerals? And then my third question is, at this point, the uranium from this mine, uranium from this mine that's going to the United States, approximately what percentage market share of the total product of this mine does that export to the United States currently represent, as opposed to the uranium that's going to China? And is it the perspective of the Chinese management once the Rio Tinto contract to export to the United States expires? Do you think it's their perspective to try to continue selling uranium to the United States, or are they waiting for that contract to expire so that they can take more of the uranium to China as the primary consumer?
I think the first two questions, the relationship of the movement of independence and the nationalization of mines, I think Comrade Antenya will best answer that one. I'll answer the last question of the uranium that Rossing produces. What percentage of the uranium goes to the United States, and whether the Chinese management will still continue? I think when you look at what Comrade John said in the opening statement, is that the contracts are binding. So they have a fixed date to when these contracts will finish. The percentage as to what goes to the United States, that we don't really know what percentage goes, but we know that for sure when these contracts run out, the Chinese, the Rossing will not be giving or producing uranium for any other foreign country except for China, because in the handover of when Rio Tinto handed over the majority shareholder, one of the statements that were made by the Chinese management was that they need the uranium for their own consumption. So they will be taking over that uranium, and it will not be going on to foreign countries. I hope that answers your question. Comrade John, can you assist in answering the two other questions, or the one about the relationship? And then again, when it comes to the trade unions and nationalizations of mines, it is every union member's dream that mines one day belong to us. I'll make an example of when Rio Tinto, when they gave their shares or sold their shares to the Chinese company, one of our demands as a branch was that Rio Tinto donates the 18.6% shares to the Rossing workers. Why? Rio Tinto has been mining in Rossing for the past 40 years, and they've enjoyed the peace and stability that this country has offered them. And at the forefront of production of this uranium was the employees. And they just wanted to leave, or they just left Rossing just like that, without even considering the employees that kept them running for all these years. So one of the employees' demands was, at least Rio Tinto must leave us with a golden handshake by donating the 18.6%. Now, in receiving the 18.6%, one of our plans was to give 7% to the Namibian government, because the Namibian government only owns 3% in Rossing uranium. So we wanted at least the government to own in double figures. That was one. And then the 11.6% will remain with the employees that work for Rossing. So they rejected the demand. they said that they are not going to consider even donating. So the demand went as further as to the new majority shareholder, and we wrote them a letter to say, can we not get shares from you as employees that work for your company? And it was also rejected. So I hope that answers your question.
I do remember the issue of nationalization. I believe nationalization is not on the agenda of the. It's not on the agenda of the government. Why am I saying this? To echo what Comrade George has just rightly said, when we tabled this demand, we wanted it to form part of the agreement. So these demands were brought to the attention of the Minister of Mines. They are brought to the attention of the Competition Commission, which is a directorate of a Minister of Industrialization and so forth. But we were not supported in any way. We were not supported in any way. Of course, if it was on the agenda to nationalize, this was an opportune time for them to walk through to make sure that they realize this agenda of nationalization. So they have no agenda. And recently, they made some amendments to the Mining Act. Recently, there was some amendment to the Mining Act, and ownership of mines was not touched. The only thing they touched is basically the issue of ownership of EPL, but not ownership of the mine. Recently, there was an amendment of the Mining Act, and they did not touch on ownership of mines. The only thing they touched on is the issue of EPL, exclusive prospecting license. That's where they said, okay, Namibians should own the majority of in exclusive prospecting license. So in terms of the government, it's not on their tables. They don't intend to nationalize mines, not at all. What was the other question?
I think I answered both the other questions.
Yeah. So before I go to the next question, I want to introduce my dear sister, Eunice Howe, that joined us just now, working in partnership with me at the Labor Council here in Washington. Eunice?
Hi, everyone. I'm sorry I'm late. I had another meeting, but yeah, thank you, Brother Gabriel, for the invitation. I'm with Unite Here, Hospitality Workers Labor Union up in Seattle, and also with the Asian Pacific American Labor Alliance. I'm proud to be in solidarity with everyone here. Thank you for sharing your stories.
Thank you.
What I would like you to address is the issue of not just your mine, but other mines and other facilities where union leaders have been removed. And it seems that from what I understand, it's not just a question of the Rossing mine, but there have been other mines where union leadership are being threatened, and also that workers are being replaced, Namibian workers are being replaced by other workers from the company. So maybe you can talk about that, and also your plans on May Day, your plans of uniting the working class of Namibia. As I think, as in the United States, we have to unite workers from all unions, all workers against racist attacks, against union busting, like at Amazon. So it's more of not just an isolated struggle, it's part of a national and international struggle. So maybe you can talk about what's going on systemically in Namibia, how it's affecting the unions and workers.
Okay, thank you, Comrade Steve. I will quickly I'll answer on that. Then my colleagues will come in. I'll start with the mining sector. When we were branch executive committee, me and Comrade George formed part of the regional executive committee. So we were part of the overseers of the whole mining, of the whole labor-related activities within our region, Irongo region, in terms of the mining sector. And in our meetings, we dealt a lot with these issues of foreigners taking over Namibian jobs. And in most cases, this is mostly Chinese. especially the marble cutting, the marble mining, and the granite sectors. The Namibian employees are being replaced. The operator employees, people that drive things like trucks, operate forklifts, operate these easy machines, they are being replaced by Chinese employees. By Chinese, they bring in Chinese and then they replace them. Not only that, even during the road construction, recently in Swakopmund, we had a road construction between Swakopmund and Walvis Bay. The people that are driving those trucks, normal truck, 30-ton truck and lesser, they are Chinese, imported from China. Even the governor of the Rongo region, the late governor of the Rongo region, spoke out on the national TV that this is quite unbelievable. Namibians can drive trucks, they have the licenses, but the people that are driving these trucks are foreigners. It's quite surprisingly. And then there was a construction of the expansion of the harbor, the expansion of the harbor at Walvis Bay, 30 kilometers from where we stay. The expansion of the harbor was given to the Chinese state-owned company. And when they started off, 99% or 90% of those employees were Namibians. But then this Chinese employer made the conditions of employment unbearable for Namibian employees. And in the middle of the project and towards the end, 90 to 99% of the workforce ended up being Chinese. And this is a reality that's currently on the ground. And most of those Chinese, and these are operators, these are laborers and all those stuff. And most of these Chinese, after the completion of this project, they never left Namibia. They are in some camps. So we believe these are some of the operators that are now being distributed among the sister mines and all those stuff. We have our sister mine, Swakop Uranium, the same problems that they were facing, the same problem that we raised and that we faced. They are facing exactly the same problems of foreigners, especially Chinese, coming over with no qualification. They are not better qualified than Namibians. Nobody knows what is their qualification, but they come to us, we teach them skills. After teaching them skills, they take over our jobs. And this is some of the issue that was raised with our sister mine. We are just, I think, 10 kilometers or 15 kilometers away from each other. And also, the union busting did not start with us. It started with a Chinese company at our sister mine called Baifeng or Beifeng. They did exactly, Beifeng. They did to those executive committee exactly what they did to us. Dismiss the whole branch executive committee. When they realized that they've done it illegally or unlawful, they went to the regional executive committee of the union, our same union. And this union convinced those employees that were dismissed illegally or unlawful to come back. When they came back, some of them came back, some of them refused. Those ones that came back, they were then dismissed legally, so that even if they go to court, they cannot have a case to present. So the issue of Namibian employees being replaced by foreigners, especially the Chinese, is a very serious issue. And our leaders, they do not see the extent that it affects us. We are already a nation whose unemployment is very high. We are already a nation, although we are rich in resources, but in terms of livelihood, we are most of us are very, very poor. Most of us are very poor. We so poor that we cannot afford bread, for that matter. But yet, when there's an employment opportunities, these employment opportunities are taken up by foreigners. So in terms of investment, we do not see the reason why foreigners should come and invest and exploit our resources, at the same time also exploit our employees. So the mining sector in Namibia has become a very bloody industry. And currently, there's no difference between what we experienced during the apartheid era and what we are currently experiencing, because the rights of employees has actually been removed. The rights of employees being removed. And one of the major indicator is our dismissal. Rossing being the forerunner of unionism, especially in the mining industry. Our dismissal and the lack of support from both the government, the politician, and our union national leadership is an indication that unionism in Namibia, if we, the dismissed 9, do not stand up and do something about it, this is the grave of union. This is the end of union in Namibia, basically.
Yeah, just to add or to echo to what my chairman is saying, it's true. The situation at the mines have worsened. As the chairman rightfully say, Rossing was an employer of choice, but now when people see advertisements at Rossing, they shy away from applying. One of the things that the chairman also left out was after our dismissal, the branch elected an interim committee or a committee that can temporarily take over the running of affairs on the mine. The management sided with the regional chairperson or the regional team, the regional chairperson and the regional secretary, to convince members that they should set up that committee and have votes or put in a puppet committee that they can control as a company. So elections were held, and the members that we thought are fit to be taking over the branch won the elections, and the company dismissed the newly elected chairperson without a hearing. He was just dismissed with a letter for things that he did at the previous employer about 4 to 5 years ago. So employees now currently at Rossing are afraid of challenging the management or standing up for their rights because they are being victimized left, right, and center. And if you speak out to anything that you see wrong, the management targets you and get rid of you. That is one. The other thing is, Comrade Steve asked on May Day what we are planning. One of our plans on the May Day or the road leading to May Day was to do site visits to most of the workers at the mines and this marble cutting industry, so that we can revive our union or get back that motivation in the workers so that they can stand up for their rights. That is our program that we strongly want to run. We believe that we are going to we are setting up a date with the former dismissed branch executive of the Beifeng, so that we can get their story and then we can tell the story to the world also.
I just want to jump in here because it's important that we share our knowledge and information that we got between our union, between our history, and between our struggles. Yes. And it's important that I bring this up because, I want the workers in Namibia to understand that the tactics of the corporation are the same wherever you go. Yeah. And when I'm saying this is because I want you to focus on the struggle that you're dealing with there and not on the workers that they're exploiting, just as the same way they're exploiting the workers there in Namibia, into creating a distraction so your focus is not on the real perpetrator of the damage, right? And I'm saying that because I can take you all the way back to 1934, the ILWU, when white workers was striking for better condition, better pay, healthcare, and all the different stuff. And what the employers did, the bosses, they went to the South where blacks are mostly poor, don't have no union, and they bring them back to cross the picket line and create a distraction and put workers against white workers against black workers. But we had a great leader, Harry Bridges, who understood the solidarity between workers and workers coming together that we can beat this corporation attack. And what he did, he went to the black churches and meet with black leaders and talk to the workers and the leaders and say, you know, if we win this contract, we'll bring the black workers into the union as well. And that's why right now you see black workers like myself in the ILWU. Okay. So this is our technique that they'll use, because you got to look at these workers that they are bringing in are workers that are exploited, workers that are probably making less than the workers there right now, because that's all they got, right? So we want to focus on the real thing, which is the company trying to violate labor rights, coming in our country, stealing the resources, and bringing in workers to shut them out or stop the food from coming to those that are deserve it, that's been living in our land, that's because they are part of that inheritance of that resources that is in that country, right? So we want to make sure that we focus on the battle and not at the individual that are being exploited as well, right? Because it's important. This is what they're using to distract you, destroy your movement. And the fact that they, you know, we know the deal. We get leaders also that get buy out and go the other way instead of the right way. So we have to focus on and keep strong and make sure that we don't get tied up in that. And we might win a fight but lose the battle. You know, we want to win the fight and win the battle. So I just wanted to bring that up because it's important that we have our eyes open, our ears open, and we're willing to unite, even with Chinese workers that have been exploited, to win this battle. It might take all of us together to do that, you know, but the right for the workers there is not being represented properly, and you deserve to have what is being part of your natural resources. And the fact remains that corporation comes and make billions of dollars off your resources, and then you have not get nothing out of it. It's not right, and it should not be left unresolved. It should not be left without a movement to change that. But we have to be strong and make sure that we focus on who the perpetrators are.
Add 2 points to this discussion. The union movement at its leadership level is in crisis here. When the Chinese brought in first building workers and then other contract workers, they brought them in on extremely savage conditions. They work extreme long hours, they carry heavy burden. What we suggested to these unions is that they should take a stand against these savage conditions under which Chinese workers toil. Now, the Chinese are not bringing in these workers specifically to put in Chinamen in positions here. They bring them in because they cost nothing, almost nothing. And workers here have already won union rights. That is the dichotomy that you have here. And the point is that while there should be a struggle against displacement of workers, there should be, it will be a very tactically and strategic position is to fight against the savage conditions of Chinese workers, that the Chinese workers are being put under by Chinese companies. And that should be part of the trade union struggle here. The second thing is that because of the treachery and the degeneration of the trade union leadership, a new trend has arisen here. They open up unions like you open up corner shops in this country. I think there's more than 70 unions now, and it's already become a point of debate. The workers should not abandon their unions. They should insist on their rights in the union to correct their leaderships. And they should reduce this tendency to open up new unions, because you leave the one union for corruption, you build another one for corruption. It doesn't work like that. It is what you do to your union. You must use your union, use your full rights to oust the corrupt and treacherous leadership. If those are not part of your tactics, it's going to have a serious problem. Now, on May Day, I have discussed with some of the comrades, I think Comrade George also, that we bring all these workers who are now currently in struggle, because they are all over, not only in mining, but in other areas like in the food industry and so on. They are under massive national struggles. There's this national strike that took place. These workers have to be invited in, and their leadership and a real program of action should be discussed on these points, so that they can formulate and conceptualize the way forward.
I really want to thank the previous speakers for really building context, because I think here in the US, we weren't clear around the historical context. And really this speaks to Letha's question. If we talk about the relationship between the historic liberation movement and the union movement. But I'm really thinking through a lot of what has been shared. And my question is related to the idea that we don't want to just hack at the branches, but rather chop at the roots. And if we think about the relationship between the Namibian state and the Chinese state, you have to understand that we're not just dealing with any other corporation. We're not dealing with Rossing. So I didn't mention this in my introduction. Apart from my work here at UC Berkeley, I'm also the chairperson of the Namibia Institute for Democracy. NID is one of the oldest think tanks in the country. We were established in 1991 as a nonpartisan think tank. And over the most recent history, in the last 3-4 years, we've been engaging both the state, civil society, and even the Chinese embassy in Namibia, to really understand what the root causes of some of these challenges are. And if I recall from some of these conferences and these deliberations that have been held, it became very clear that a lot of bilateral agreements that are agreed between the state and our Chinese counterparts, even though they're corporations in name and in structure, they're still nationalized companies, these entities of the Chinese state. And these agreements are often on a state-to-state level agreed upon or discussed behind closed doors. There's almost like a veil of secrecy. And this is why we find that when there's a people-to-people interaction, there's disconnect. But then also on the converse, on the other side of that coin, we talk about bringing unions together in a cohesive manner. We want to pull in the same direction. But one of the reasons why there's such a proliferation of various unions and even political parties in Namibia is because Namibia is still highly ethnocentric. And so my question is how, and if I have to go back to my constituents, young people, youth, young Namibians who want to support this movement, how can I sell this movement as an inclusive, intersectional movement? How can I sell it as one that allows the voice of those that typically don't occupy these spaces? And how do we ensure that it's not another ethnocentric endeavor? Thank you.
I need to comment on that. The history of Namibia is one which shows that the union movement itself has rubbished the idea of ethnocentricity as the main moving force. By 1978, despite the existence of various tribal parties and so on, the workers united without any tribal sectional interest having a bearing on it. They united at that very Rossing all the national groups, and they united around a workers' program. The issue of ethnocentricity, which you mention in the Namibian context, is partly because of the Bantustan policy of South Africa, which gave the tribal pre-capitalist structures more weight than what they were really worth. And it had impact on your constitution of your opposition parties here. But the workers have been uniting on a non-sectional basis. That is proven by various young parties in the country. But nevertheless, around the workers' issues, workers have united irrespective of tribe or nationalism. And the same is true for South Africa.
One of the things that everybody is on the same page about building our united front in farming workers. But I'm going to tell you this, brothers and sister, that the days of just protesting, the days of just marching, we already been there, done that, right? And we're still in the same struggle. But one of the things that I have seen that I'll continue to work each and every time is when workers become part of a movement. And when you say a movement, what is the difference between a movement and a moment? It's sacrifice. We have to be able to willing to do sacrifice, just like you brothers are doing right now. But the sacrifice has to escalate in a level where you put a hurt on the corporation. And the only way you can hurt a corporation is in their pocket. That means you shut it down. That means nothing moving till they come to the table. That means shit. Like I'll give an example for back in when a brother by the name of Leo Robinson, who was a member of ILW Local 10, and also I'm founding member of the Coalition of Black Trade Unionists in the Bay Area. He organized a protest at the terminal where the South African cargo was supposed to be unloaded. The longshoremen have a tradition that they do not cross picket line. So when that picket line was put forward there, no longshoreman passed to go work that ship. It started a movement. Anywhere that ship went, nobody would unload it. Eventually, it put a cramp on the South African government and the economy, and eventually it also played a role in the freedom of Nelson Mandela. So this is the kind of action that we have to be thinking about when we want to beat corporation, because they can outmatch us with their money. They can buy government and buy people to come do a job. But one thing they cannot do, they can't move those cargo nowhere once we shut it down. And that's going to be take our involvement with even those workers that are still on the job, and that's where the sacrifice comes. That we all sacrifice for a win for all, and then you don't only sacrifice, but it comes with a list of demand. There's no more we asking you. We demanding that you make sure that every worker in this country have a right to live, take care of their family, feed their family, just like you're doing. And that's what we got. That's the level that we need to rise now in the 21st century. After a pandemic 2021, there's no more playing games. It's time for action. It's time for movement. It's time for demand. And it's time to make them know that we got support all over. Because once you start the movement, it could trickle down all over.
The international struggle of solidarity and uniting all workers is what we're really about, and the only solution. In the United States right now, the government is, and the bipartisan policy are pitting Americans against Chinese, against China, which is creating a terrible and horrible attack on Asian Americans in the United States. So, and immigrants are blamed for the unemployment. So in every country of the world, it's not unique. A rise of xenophobia, a rise of racism is what happens in a capitalist crisis. So I think what we have to focus on is how to build internationalism, international solidarity, and uniting all workers, regardless of race, nationality, religion. We have to build an international working class movement. And I think that this effort to support the Namibians is part of that. And this is about worker rights, union rights, whether it's in Namibia, South Africa, or the United States. So there's a united struggle. So on the 19th of April, there's going to be a hearing with the arbitrator in Namibia. And we are going to have a delegation at the Chinese consulate in San Francisco to call for the Chinese government, which owns the national company that runs the Rossing mine, to rehire the miners. So our rally and our letter, and they've written a letter in Chinese and English to Xi Jinping calling for their rehiring. And I think that is part of an international campaign that we have to conduct, so that we say that the issue is worker rights in Namibia is something that has to be protected. And this is something that we can do in educating ourselves and building solidarity with the workers in Namibia, but also in China, because one of the things I learned is that the Chinese workers who are working at the Rossing mine, they work from 7 in the morning to 10 at night. They have worse working conditions than the Namibian workers at the same mine. So that's unacceptable. It's pitting one group of workers against another. It's undermining the conditions of the Namibian workers. So we have to say that that's unacceptable. Workers, equal pay for equal work. And one group of workers should not be working at worse conditions in a place because of their nationality, their race, whatever. So I think that's what we have to build. And I think that we want to thank the miners for attending. And I think this will be one of many. And, you know, I think also we're able to do this international panel, and I think there'll be more of them, workers from all over the world, whether it's China, South Korea, or South Africa, using the communication tools. We have to build internationalism and education for workers to join each other and fight together. And that is really the only solution for working people around the world. And on May Day, we're going to be having a march in San Francisco. All the unions in the Bay Area are going to be marching. And the Secretary Treasurer of the AFL-CIO will be speaking. He's an Ethiopian American. And the ILW Local 10 will be leading that march in San Francisco on May Day. And what we need to do is bring all workers together, particularly Black workers, Asian workers, others who are under attack. And the fight for unionization, the fight for the rights at Amazon and all these companies is critical in that task.
You see the Namibian, when you see the Namibian, you are going to see the Namibian embassy or what? Did you say something like that? You have to demand that they extend, because our law compels is compulsory on the government to protect the rights of workers, to protect certain standards. They must extend the protection of workers to the Chinese workers too. That work.
Maybe from our side, we, as you know, were dismissed abruptly. It was not planned, and as a result, most of us are actually, even if we want to organize, even if we want to, of course, we want to organize, we want to mobilize and reach out. But the biggest challenge that we have is that we are all financially crippled at this moment. We're all financially crippled, and for us to be able to move around and do all these things, it requires a lot of resources and transport. This is one of the really appeal that we are having, that if we can get financial assistance, we can make the organization of the workers much better, and we'll be able to reach out to all the unreached colleagues that are suffering the same like ourselves.
I want to thank everybody for participating in this discussion. And I'm looking forward for us to continue this discussion and follow through with where we at and where we going from there, from where we at, you know, because we're going to make it a movement and not a moment, right? And that's what it's all about. To get victory, we got to be able to build a movement, you know. Being part of a movement has teach me that we can advance in many things once we got a movement going, you know. So I thank you all. I will see you on the next Zoom meeting. And power to the workers and power to the people.
Power to the workers, power to the people.